This is a panel. The title of the panel is Constitutional Design by Judiciary. It's wonderful to have three very dear friends join us today. Ros Dixon, who teaches at Columbia and the University of New South Wales, Mark Tushnet, who comes from Harvard, and Anna Sue, who teaches at the University of Toronto Law School. The plot for the panel is a paper, a paper that is long but doesn't feel long, that Ross wrote. And I know that some of you might have seen the paper. It was circulated to people who asked for it. So some of the commentators might respond to that, but the theme is generally important and can be introduced in a way that is, and I'm sure Ross would introduce it in a way that doesn't require sort of the reading of the entire paper. So we'll start with Ross, and then we'll go to the commentators, and then we'll open it up for conversation.
Thank you so much, Vlad, for the invitation to be here. It's wonderful to be back with Katie and Vlad, who taught me everything I knew about constitutional law as fellow graduate students, and to have Anna and Mark to comment on this paper and to get the chance to be at BC in this beautiful campus and be hosted by the Clough Center. I'd like to thank them for all the organisation for today. So the time is short, so I will just outline the idea behind the paper and leave it to commentators to show you some of the detail and where the challenges might be. So the motivation for the paper is the idea that in the US founding moment, the key players at Philadelphia went on to electoral politics or elsewhere and not to be central players on the US Supreme Court. And therefore, we haven't paid that much attention in the US Academy, at least, to the crossover between those who write constitutions and then go on to be central interpreters of the documents that they write. Whereas in many other parts of the world today, the opposite is the case. Drafters are, in fact, central players in interpretation, and that there's this fusion, if you like, of roles that is incredibly common in new constitutional democracies. It's true in Colombia, in Indonesia, in Hungary, in South Africa. You can actually trace it back, quite a lot through the 20th century, starting with Kelsen. Australia is also another, very interesting example. And so the paper tries to suggest that studying drafter judges, people who write constitutions and then interpret them, is more important than the American experience suggests. That drafter judges are a phenomenon, and they are a phenomenon that in fact seems to be associated with very successful moments of constitutional transition in a lot of cases. And so it's a kind of interesting puzzle to think about what might explain how common they are. Now, it could be accident, right? It could be that they are just, we are seeing them in a particular lens, and it's entirely accidental and contingent that they were drafters. But I want to suggest in the paper that it seems to be more than that. There's obviously contingency, but there's some kind of common thread that we can tease out. The paper suggests that there are two lenses for thinking about that. One is a kind of reverse originalism story, right? If you're a drafter and you're worried about how the document might be interpreted, better to put your fellow drafters on the court so that they'll ensure that the text is interpreted faithfully by reference to the original intentions of the drafters, right? So it's a version of originalism that is not the dominant one in the United States today, where original public meaning tends to dominate, but nonetheless a version of originalism that we can understand, dating from Powell, and that makes sense. Although ultimately in the paper I suggest that there are a lot of holes in that argument. It's not necessarily a persuasive argument to say, well, I was there, therefore that's what the text means. It's not necessarily even a particularly unique set of claims that I know what it means, given how much in the 20th century drafting takes place in public or through public input. And at least over time, you might have an external viewpoint, and some drafters themselves might share that viewpoint, that suggests that from a more living constitutional perspective, people who wrote the document might have blinkers on and may be incapable of adapting the document to changing circumstances. And I have a couple of neat examples in the paper from Canada and New Zealand of judges who were very central in drafting the text and who were kind of angry when people suggest that it was capable of evolution, right? And they were like, no, it's not. So ultimately, I suggest that reverse engineering originalism is plausible and persuasive in some set of cases, but can't explain the full phenomenon. I then go on to show that there is interesting continuity between the role of individual judges at a very deep substantive level in particular areas like same-sex relationship recognition for Justice Sachs in South Africa, for peace building and constitution making for Justice Cepeda in Colombia, and say that those continuities help draw our attention to the continuities between drafting and interpretation itself, right? That they are not radically distinct moments or exercises, that there is, you know, law and politics on both sides and judgment and skill on both sides, and that if we have that view of the judging interpretation versus, you know, writing, drafting moment, we'll have a different sensibility about the kinds of judge that are most likely to be desirable from the perspective of building a new democratic constitution. And with that lens on, I go on to argue in the paper that you might see drafters not so much as uniquely interesting or advantageous, but as representative of a subset of judges who you might call skilled lawyer politicians. Judges who have political experience and yet legal skill and commitment, right? People who care about legal drafting and text and language, and yet who are people with political relationships to leading political elites, with a set of demonstrated and honed skills at, you know, crafting political bargains and deals, and in many cases with a quite distinct set of ideological or political commitments that are often shared with or known to others in the drafting process. And that itself can reduce the likelihood of strongly counter-majoritarian interpretation in the first generation. You know, you see in India where you had the exact opposite of lawyer politicians on the court, this long battle between the parliament and the courts over interpretation because they were highly counter-majoritarian in how they interpreted language. And secondly, the idea that if you know how judges are going to interpret open-ended language, as a drafter, you are much more comfortable enacting open-ended language, right? Much safer to have parsimonious kind of US-style constitutional language if you know the broad philosophy or politics of the judges in the first generation who will interpret that language. And so the final argument is that knowing who judges are going to be based on sitting in the room with them, and, you know, it's often a room just like this, but one that one spends a year, you know, 2 years in, hashing out a document. You know people pretty well by the end of it, right? And so knowing that allows the drafting process itself to be less costly, less time-consuming, less likely to fail through intractable disagreement. All of those are contingent. They won't apply in all circumstances, but I trace them as plausible explanations for the experience in the range of countries that I'm interested in. So with that, I will turn it over to Mark and Anna and invite your questions and conversation.
Hello. So thank you for inviting me and for this opportunity to comment on this very fascinating paper. So the paper, as I understand it, refutes a long-standing assumption that there's a strict divide between constitution making and drafting on the one hand, and constitutional interpretation on the other, by looking at this phenomenon of drafters as judges, that is, those who write and, you know, are confined to the writing and adoption stage of the Constitution, and then later on, as a member of the Supreme or Constitutional Court, is now tasked to interpret those provisions. And looking at these types of judges, particularly in places such as South Africa, Colombia, Indonesia, then tells us something important about the character of judging in a constitutional democracy. So the paper notes the drafter here, the term drafter may vary in terms of their proximity to or the degree of involvement that they have with respect to the constitutional document produced. So either they crafted the actual language in the document, or they were participants in the general negotiations surrounding the Constitution. But that said, what they all have in common is this distinctive knowledge and experience, which they then get to apply when they are faced with the task of interpreting a particular provision. And I think that raises my first question, which is, does it matter that, does the exact role of a drafter during the process matter in the sense that they would feel more responsible or feel more pressure to implement a particular provision in a particular way because they've had a hand in drafting the actual language rather than if they just advise generally. Right? So, but given that knowledge and experience, I think the paper already usefully notes that the information-related advantages of this experience is quite limited for various reasons, but that its significance lies elsewhere. And one is that drafter judges are a refreshing and novel vantage point from which to examine this spectrum between constitution making and constitutional interpretation. I guess most constitutional drafters deliberately leave text ambiguous because that's the only way that they could get agreement from everybody on the bargaining table, right? So that's one reason, or a simple recognition that their knowledge is quite finite, right? And so it could be a purposeful delegation of this constitution-making task to the soon-to-be-created constitutional courts. So in either of the situation, the drafter judges who presumably possess a broad vision of what the Constitution is meant to achieve, then gets the chance to apply that vision or persuade his or her fellow judge to implement that vision later on. But one less obvious and I think really important way by which drafter judges get to ensure the stability and continuity of a particular constitutional vision is how they contribute to the creation of a constitutional culture. And some scholars have suggested that there's no measurable analytic difference between vague and specific constitutional provisions. So when we look at it, sometimes constitutional interpretation is not constrained by text, but actually by the politics surrounding it. And so it would be interesting to see a discussion of the relationship between having drafter judges and the constitutional culture that gets created around the document, and that will fill in or render intelligible some of the indeterminacies that are found in the constitutional text. And by constitutional culture here, I simply mean those values or informal social understandings that help understand the bigger context of the Constitution. One example here that comes to mind is that of Aharon Barak. I don't think Israel is mentioned as an example in the paper, but Aharon Barak, the former president of the Israeli Supreme Court, was a key advisor during the legislative deliberations over the basic laws, which serves as Israel's constitution, and he's credited with almost single-handedly justifying and enhancing the role of the judiciary in order to further the project of democratic constitutionalism in Israel. So the other interesting avenue that I think this phenomenon of drafter judges opens up for further reflection and research is the matter of judicial appointments. And I think the paper glosses over that too quickly. So there's the institutional aspect of judicial appointments. How do you get to appoint precisely the kinds of judges with the necessary skill set, political and legal, that you want these judges to embody? What should be the optimal institutional design, the kinds of structures that drafters should consider to establish courts with politically savvy judges. And here, and also especially in divided societies, how do you get judges with representative viewpoints or backgrounds represented on the bench? And generally speaking, the legal and political skills of a drafter judge, though not limited to them alone, I think, are necessary to facilitate a necessary dialogue between courts and the legislature, and that dialogue, or at least that trust between the court and legislature, which might be a bit precarious during the early years of a new constitutional order, so that it's not only the political elites that should trust judges, or that they trust those likely to be appointed to the court, which is what happened in South Africa. But I think it's also important that the members of the court themselves should have the political skills to consciously address concerns about their own legitimacy. And I think I have here in mind an example from Canada. So before getting an appointment to the Supreme Court of Canada, Justice John Beats served as a special counsel on constitutional affairs for then Prime Minister Pierre Trudeau and was heavily involved in the various rounds of talks during the constitutional reform process in the years preceding the adoption of the Charter of Rights and Freedoms in 1982 and the patriation of the Constitution. And at the time of the adoption of Canadian Charter, most of the concerns in Canada at the time was that the Supreme Court would be given lots of power, that they would engage in the same kind of judicial activism that the Supreme Court here in the United States are engaged in, or at least that was the perception from Canada. And so Justice Beets, who was one of the, who was influential during the early years of the Charter, he was known actually for following a strategy of judicial restraint in order to, perhaps out of recognition of these concerns, and perhaps in order to build the necessary capital for the court to use later on when they decide more contentious cases. So here are some of the other questions that came to mind while reading this paper. One is that given that drafter judges are like lawyer politicians, it's probably not a coincidence that the main examples of this paper, particularly South Africa, New Zealand, and to a certain extent Canada, were among those constitutional revolutions that Rand Herschel mentions in his book Towards Juristocracy, where he talks about the rise of hyperactive constitutional courts and then attributes a political explanation for this phenomenon, particularly that various kinds of elites, political, judicial, economic, interact in order to protect the status quo. And if we place these courts within that context, then it becomes easier to explain why these courts have played such a central role in the successful process of democratic constitutional transition in these places, right? And so I wonder if you would agree with such characterization, and if so, whether the term drafter judge is really just another term for the judicial elite mentioned and described in Herschel's account. Another one is, how does this account address rule of law concerns that explain, I guess, the belief that there should be a separation between interpretation and drafting? So if you have the same judges interpreting what they drafted, the paper already notes that there are certain good outcomes from that. But what happens if they were in the losing camp during the drafting process, and then they try to win in court what they lost in the deliberation room? So that's another question. And finally, I'm wondering if it can go the other way. So should judges be preferred as drafters, and would that make a difference? What does that look like from a democratic perspective?
Thank you, and I also want to thank the Vlad and the Clough Center for sponsoring this. I'm going to pick up on some of the themes, particularly about, as Anna phrased it, judicial appointments that she identified, although in a slightly different way. The motivating force of the overall paper, the large paper, is that we can identify a class of people who are, I'll put it this way, continuous between the drafting stage and the interpretation stage. That is, these are the people who were at the constitutional draft, in the constitutional drafting process, wherein has some flexibility, close advisors to the drafting committee, even though not formally part of the Constituent Assembly, for example, would count in this kind of way, I think. So there are these people who were there, and they become judges on the Constitutional Court. For analytic purposes, I think what matters most is that there be a relatively either no gap in time or a relatively short gap in time between the presence in the Constitutional Convention and the appointment to the court. The thought is, the initial thought motivating the argument is that those people who are continuous in that sense, have a variety of advantages as interpreters over other people, okay? And then as Roz works out the argument, it turns out not really so. They have characteristics that are in some dimensions helpful and in some dimensions not helpful, compared to people who were not continuous in this sense. And in the paper, there's one, I think I find pretty dramatic example of the sort that Anna raised at the very end. As I understood the facts, the two of the three first Australian judges were losers in the drafting process. Now you can imagine that that's going to have effects on their interpretation, the way they interpret. It doesn't have to be that they will try to win as interpreters what they lost at the convention, but
They did.
maybe they did, but it's not necessary. They could also just, on close questions, shade in the direction that they favored as in the convention. Okay, so there's that group of people, but it turns out that that group doesn't really, or the mere fact that they are continuous in the sense that I've described, turns out not to tell us all that much about the interpretive process. But there's a second group which is also continuous, but it's a different, or these people are a subcategory of that larger group. And the larger group are, as I think of it, as political legal elites associated with the Constitution formation project. And so here, I think, the image I have in mind here is in fact from the United States, where although the initial judges on the US Supreme Court were not, with one exception, Wilson,
And Rutledge.
Rutledge present at the Constitutional Convention, all of them, and all of the first 10 or so, were part of the political legal elite of 1787 and 89. And in terms of knowing each other inside the room, well, they may not have been in Philadelphia, but they were military aides to George Washington during the Revolution, or they were members of the Continental Congress or of the Congress under the Articles of Confederation. And so they knew themselves, they knew each other in the relevant kind of way. And it turns out, I think, that, at least Roz's argument is, that that kind of knowledge, the knowledge of each other, which is not confined to the drafters, those present at the drafting, that kind of knowledge turns out to be helpful in constituting a constitutional court. Because it helps people identify, all right, let me put it this way. This is from one of Roz's formulations. The qualities that make you successful in drafting a constitution that works turn out to be qualities that make you successful at interpreting a constitution once it's in place. The easiest way to think about this, I think, just to see the contrast, is that if you figured out how you can get, in the US example, Congress and the president to work to promote good governance in a cooperative/competitive kind of way, if you figured that out, chances are pretty good that you're going to be able to figure out decent interpretations of interpretive questions or constitutional questions left open at the framing. Okay, so the qualities of mind or political skill that work at the drafting stage are useful at the interpretation stage. And that leads me to my final point, which is I have it in my notes. There's this great line near the end of the movie Butch Cassidy and the Sundance Kid, where they've robbed all these trains and they've now escaped to, I think it's Bolivia, and they're being chased by the railroad army hired by the railroad. And they look out and they say, who are these guys? Right? So here what I have in mind is, well, who are the other people, the discontinuous people, the ones who are not part of the political legal elite that was part of the Constitution framing process? One might think that once you created this new Constitution, you would choose to staff your constitutional court with your, in some sense, friends. They don't have to be political allies, but folks you know. And then the puzzle is, not the puzzle, but the thing to wonder about is, well, how come there are people who don't have that characteristic on the Constitutional Court? And here, I think there are, what I would want to think about is, I would phrase it in terms of, under many circumstances, a new Constitution is a rupture with the past, but for political reasons has to maintain some degree of continuity with the past. And it could be that what one can observe in these new constitutional courts is that who are these people, judges, are the mechanisms or are the representatives of the past. So I would, at some level, I would want to know, I don't know this, one of the examples in the paper is the First Constitutional Court of Hungary, which was led by Justice Solja. Can't pronounce it right. There were a bunch of other people on the court, not all of whom were on board with his vision. Why were they there? And I think the answer is almost certainly that the previous regime had sufficient political force that it had to be accommodated in some way. We know it was accommodated by not having a new constitution entirely. They amended the Constitution quite substantially, but did not adopt a new one, and that was for these political reasons. Maybe that's true on the appointments to the courts. And then finally, just the absolute last point I want to make here is there's a gap, a problem in the literature on new constitutional courts, which is that we, including me as scholars, focus on the success stories. And there are a lot of new constitutional courts. The former Soviet republics all had constitutional courts. None of them turned out to be heroic constitutional courts. They occasionally did a little stuff, but mostly they were just blah. And I think there's information to be gained by studying these constitutional, not quite failures, mediocrities, as well as the heroes. And just finally, to tie this, it might be, I really don't know, it might be that you would find on the mediocre courts the same continuities that Ross singles out on the heroic courts.
So why don't you take a few minutes?
Okay. So these are marvellous comments and extremely helpful, and thank you to both Mark and Anna. So I guess, in reverse order, I think that's right, Mark, that, ideally one wants to study both kind of success and failure and try and get, inductive lessons from that. I can only imagine the wonderfully warm response from law reviews one would get from a study of mediocre courts, but nonetheless the point is well taken. I do have an example in the paper of the Russian Constitutional Court where Zorkin was not a formal drafter in the sense that his efforts in the early 90s to help draft a new constitution were ultimately unsuccessful. So in a sense, he was a loser drafter, and then appointed as the president of the Constitutional Court, and saw himself as very much the lawyer, politician, statesman. And for a moment, he was Time Man of the Year, was incredibly successful. Essentially, he didn't know when to stop being a lawyer, politician, and be, just a judge. And, he brought the whole thing crashing down upon himself and the country. So I do try and draw out some salutary lessons about the limits of, the lawyer, politician category or type from Russia, and say one has to be cautious about saying any of these things as advantages if they're not tempered by an appropriate sense of humility and the judicial role. But I definitely take the point about, one needs the full picture. As Anna says, one really needs even to think about the flip to get a proper appreciation of, the parameters of what we can say. On the alternative, I think Mark is politely suggesting that there is no alternative to the class that I'm identifying. I do think there is, and particularly because I have a related paper about draft, which is called Constitutional Drafting and Distrust, and looks at the language of constitutions and how specific or general they are, and the relationship to kind of trust in judges. And again, I'm drawn back to India, where the entire original tribunal charged with interpreting the constitution, they were just lawyers, right? They were sitting members of lower courts, high court judges, and very traditional English-trained common lawyers who were chosen distinctly because they were seen as apolitical, regular practicing lawyer, good lawyer types, not people associated with the Congress Party and the kind of founding spirit. So I think the alternative, and in many, both of you flagged appointments as a question, the alternative is often sitting judges, either, an alternative to lustration, people who are on an existing court, keeping an existing court, or appointing to a court pretty, regular lawyers or people with judicial experience. And I think you can see that. That was certainly some of the other judges in South Africa, although they were known to be at the progressive end of politics. They were very ordinary judges. In Hungary, in my travels on this paper, I found the most interesting thing, that there was actually a sequence in Hungary where they got to a kind of deadlock moment in the drafting on the language, and they said, all right, let's just kind of break out, we'll move to that table over there. And they came up with a list of 5 names that were agreed as the first 5 members of the Constitutional Court, which were a mix of kind of somewhat communist sympathising, somewhat opposition affiliated, but sufficiently centrist to be acceptable to both. And then they said, okay, now we've agreed those 5, now we can get on with drafting the rest of the language. And that is, to me, a beautiful illustration of my point about the pressure on drafting, is if you know that you can trust the judges, it can alleviate pressure. So I do think that the alternative exists, and it is more of a traditional lawyerly class, although, as the US founding reminds us, whether or not there is such a class will depend somewhat on the political culture and the context. In some societies, particularly small ones where there is a very little pre-existing legal culture, there may not be an alternative, right? This might be the whole set of people that is open for consideration. The temporal part, I think, Mark, you made that point to me in another context before, and I do think I address that as that, continuous seems pretty much the category, although there are some puzzling examples of non-continuous drafted judges. So that in Puerto Rico, this very kind of iconic judge was involved in the drafting and then was appointed like 15, 20 years later. And it's a very interesting kind of counterexample, because almost all the other ones are ones of very immediate temporal continuity. So Anna, on a couple of your points, I take the Israel point as, people differ a little as to Barak's role in relation to the basic law, but it is an example I should acknowledge, and clearly one that highlights the political culture as well as an association with the project as very important, and Beats is another nice Canadian example. On hegemonic preservation, which is the Rahn Herschel idea that Anna alludes to, I think Mark and I have talked about this a little, which is Tom Ginsberg's ideas about insurance in relation to judicial review and Ron Herschel's in relation to hegemonic preservation, the idea that part of why courts get created and constitutions get created is to provide a certain guarantee to outgoing political elites that their people or their policies will be looked after, are often not particularly attentive to who the judges are, right? So they're very attentive to constitutional institutional structures and even to the text, but not so much to who's going to, lock in this bargain. And that seems puzzling in a way because it's such an ultimate realist political account of constitutions. So in some ways you might see the latter part of the paper, the part about this relieves pressure on drafting and reduces the kind of drift between drafting and interpretation as in sympathy, albeit with a slightly less sceptical anti-judicial review bent than Ran's book might be taken to have, to that kind of idea, but says, well, you can't think about that kind of theory of constitution making and judicial review without thinking about who the judges are, right? And for hegemonic preservation to work, you need not just text and institutions, but judges who are sympathetic to the political project. But I don't think it's quite as narrow as hegemonic preservation because, think about South Africa. South Africa was both keeping, a set of guarantees for the outgoing, white elite majority as to protection of property and individual liberty and guaranteeing social and economic transformation for the black majority. So it was clearly a hybrid, and yet the argument works. But I definitely take the suggestion. There was actually an earlier version, an even longer version of the paper that had a lot about institutional design and appointments, and I think I came to the view that in the balance between what we can say that's universal and prescriptive and a kind of a point that says everything is contingent and national specific, I couldn't make sensible prescriptions about how you translate this sensibility into design. You would need to know a lot more about the specific political context. Certainly, one of the paths to go down is to think about the kind of distinction that Wojciech Sadurski and others have drawn between what you might call shared models of appointment versus concurrent models of appointment. So, the Indonesian model is the president gets 3 judges, the parliament gets 3 judges, and the kind of judicial branch / civil society get 3. That's sharing it, right? Dividing it up, and the others concurrent, or we all have to agree. And you might think that concurrent is more desirable than shared under certain conditions for this kind of idea, but I think ultimately it really does depend. And so even though I'd be interested to explore those questions, I wouldn't be comfortable suggesting that there's an immediate read-off or payoff from this kind of examination to what can we say about judicial appointment. Right.
Sounds good. We'll open it up. Okay.
So thanks, Ross, for this great paper. My question, I guess as you were talking, I was thinking of Chief Justice Rainford's comment about a growing international priesthood of judges when he was identifying the trend of judicial borrowing early on and what that meant for the US Supreme Court. And I was just wondering if you had encountered an overlap between the judges who are good at cross-referencing and citing other foreign courts and international law and those who have been involved in the drafting process. One imagines that there would be a considerable overlap between those interests that you might have found in certain contradictory examples. The second question I have really flows from Mark's comment about who are they, the other ones that don't go on to become, the ones that are judges that haven't had the drafting experience. But that triggered a question of mine, which is who are the others, the drafters, who don't go on to be judges? Because there would be really interesting work on the professional trajectories of these constitutional drafters, and I know many of them are outsiders from the country. Many of them would be law professors and scholars, but I imagine many of them would become counsel and advocates in cases and would have a very healthy professional life afterwards. So in your work, did you really look at other drafters and what they go on to do in that experience?
These are, great questions. I think that, again, the answers are heterogeneous as to what people do. Clearly, and sort of the US example makes us sort of start with the idea a lot of them go into government, into the executive and into elected office. And that's going to be more common in systems where you have a elected drafting body and no bar on that body continuing, right? So in Colombia, they had a bar on the Constituent Assembly. Anyone couldn't for 2 years then be in office if they were in the Assembly. But if you have, no bar on office and an elected Assembly, many of them will just continue in Parliament because they were elected on a kind of ticket that means they have electoral support. Some will go into the executive. And I do think if we take, sort of Mark's idea of the Constitution outside the courts, seriously, we'd be very interested in the role of those who go into the executive, right, and who advise presidents, prime ministers, and how to interpret the Constitution in the context of the executive branch. As you know, Sir Robert Garran in Australia, who was, a very important advisor in the drafting of the Constitution, was then a very key executive official and who did do important work at the executive side in terms of interpretation. I mean, there are obviously examples like in South Africa of, people like Cyril Ramaphosa going on to large business success. So I think for constitutional purposes, the interesting ones are the executive and the parliament. There might be ones about advocacy. I didn't come across any as in my travels of, but I do think that in that sort of setting, and again, I know because I was there as an advocate, would be highly unpersuasive. So it's more likely that we'd see interesting things at the elected or executive side. On the foreign citation one, it's a very interesting question because I think it's certainly true to say that many of these people knew each other, met each other, had some at least idea of each other. I think it differs somewhat by context. My sense is that you might regard the Hungarian court and the South African court as very conscious of each other and in explicit dialogue with each other in their judgments. And certainly I think that Scholjen would have been more likely to be cited in South Africa than other members of that court. I think in Colombia and Indonesia, not so much. And I think that goes to my overriding point about political skill, which is if in a particular political culture at a particular moment, the suggestion of external influence might undermine the perceived legitimacy of a constitution, right? This as a Western imperialist or, American or whatever it might be, sort of imposition rather than an organic domestic creation, the politically skilled judge will be aware of foreign developments but not cite them, right? And you see that in Indonesia, actually. It's a civil law country which is not out of strong tradition, but there are traces of you can sort of say, oh, I know where that came from, but they don't say it, right? And I think Cepeda was very mindful of recreating a Colombian jurisprudence that had resonances in German and, comparative experience, but without being very explicit about it. So I do think that the political skill part dominates the kind of explicit citation of this is just a club that always references each other.
So, it's a really fascinating project to think about the link between the drafters and interpreters. But thinking back about even looking at our modern court and history, the idea that constitutional actors, the judges who have a deeper understanding and intimacy and empathy with the complexity of the real life problems that are coming up is, I think, assume, and with some good reason, to say they'll at least reflect the complexity of the issues. So if you have somebody who's really worked on gender issues or poverty or civil rights, so they've come up through that, or they've come up through the administrative process, or even years ago, I did a research project interviewing judges about why they do or don't sanction lawyers in their written opinions, and it was so interesting that the judges, it appeared, too small a sample, but the judges who had actually been litigators were so much more empathetic of the momentary mistakes that litigators would make, and those who came up through a different path just exhibited less empathy and were more judgmental against lawyers. So it seems, I wonder if the issue, I appreciate you're looking for the strain of drafter versus interpreter, but is there another story which is intimate understanding of the complexity of these choices? And I didn't happen to be on the Constitutional Court, but I've lived and breathed in the Continental Congress the problems, or I've been back in the state legislature and saw people fighting parallel problems, or it is empathy of the complexity of the real life problems that might be the common skill set that makes for the best judges and pivotal constitutional interpretations and new constitutions?
I mean, I think this is a great question, and it really sort of pushes to how do we, go out from this kind of, what does this say to a broader set of questions about judging? I mean, clearly embedded in this is a sympathy for the argument that says having an entirely legally professionalised United States Supreme Court, we used to have a moment where there were senators and, people who've been in elected office on the Supreme Court, and we don't anymore. And I think if there's a sympathy in this paper, it's toward the idea that there should be people with political experience on the Supreme Court. Now, the paper does try and narrow that some by saying, well, it depends, right? If you have a completely established, consolidated court and constitution, you might have better judging if you have such people on the Supreme Court, but it turns out that not even Bush v. Gore can bring the court down, right? It's so strong that even kind of extremely bold and potentially, unprincipled assertions of judicial power without appropriate political kind of, they survive. They wouldn't survive in Indonesia. They wouldn't survive in South Africa, but they do because of the length of the institutional history. But there is definitely a degree to which, if there's any question about the court's institutional legitimacy and standing, people with political experience would be important. On the kind of broader life experience, I mean, surely people who've lived are better, elected officials, and they're better judges. I actually have earlier related work on gender and judging where I talk about some of these issues, and my own view is that gender, the findings that gender is predictive of different results in certain kinds of cases involving gender tends to be associated with questions of fact. That this is again my argument, it's not, one that's universally shared, but I am not persuaded by the kind of Carol Gilligan, Susanna Sherry argument about a different general philosophical perspective. There are feminists and then there are women, and those sets are not, the same. They are overlapping but not the same set. And so to sort of attribute to female judges, particularly those who can get confirmed, a single worldview seems unpersuasive. So my claim is, if you've experienced the world a particular way, and you're likely to see certain facts that way. So that's all a long kind of winded way of saying it depends on the jurisdiction of the court. So some of these courts, particularly those with specialised constitutional courts, without courts of being of general jurisdiction, and depending on the way they get their cases, right? So the Colombian court gets a lot of its cases via a mechanism called the tutela mechanism, which is essentially an original writ jurisdiction where they do the findings of fact. Whereas, South Africa, by the time it gets to the Constitutional Court, the facts are all done. And so I take your point I'm very sympathetic to it, but if I wanted to say something about it in this context, I would say the breadth of life experience, becomes more important the more the court is making findings of fact. The political experience becomes more important the more the court is navigating high politics, right? So if you're the French Conseil Constitutionnel, no concrete review, no, real people in front of you, political skill really matters. If you're doing tutela review in Colombia, right, should this person get dialysis, individualised, fact-based, surely to have lived in your community, to know something about public health, to know something about questions of distributive justice, to have been on the local school board, that kind of stuff helps. Yeah.
So the Constitution is a prospective document, which is telling the country how to act in the future. So I understand, and I'm not convinced one way or the other as to the effect of the drafters on the initial court. But what about 10 years down the road? What about further on? Is it, to the extent that there's any effect, isn't it just a blip during time immediately after the drafting? And that blip kind of levels off as time progresses and some of these people leave the court.
So this is a great question. I mean, it sort of has a lot of strands that one could come out of it. So one set of strands is, how do I think about transitions? And I think this is, again, an understudied topic in comparative constitutional law, the kind of movement from first to second generation, ensuring successful transition and how that works. I'm interested in that, and I don't think we've done enough work on it. The sort of second question would be, well, if you think there are advantages, right, don't they just all go away once these people leave? And, you know, I do think that even in civil law systems where the doctrine of precedent isn't formalised in the same way, the wonderful thing about judging and courts is there's a half-life to any kind of influence, right? That, you know, it might not last forever, but that the precedent and sort of jurisprudence does lock in for at least some period of time a trajectory, okay? It's not an irreversible one, it shifts, but if you think the founders kind of put meat on the bones of the draft, right? So they take the language and they put some meat on it that is sympathetic to the kind of general vision of the political elites that wrote it, that will last. It's not, you know, it can be overridden, as we know, like rival political elites can win often, you know, but it have some continuity. And then the third part of what I took to be embedded in your question was a kind of, well, you know, if these people are coming on later, isn't it irrelevant at that point, or even unhelpful if you take a living constitutional view? Because I have these examples, including from Indonesia, of this example of about state-owned resources, where Jimli Ashidiki, the first Chief Justice, kind of wrote his doctoral dissertation on the topic, was on the court, helped draft it, then was on the court. He's like, it can't possibly change, right? Everyone wants it to change to allow, you know, foreign investment and the IMF to do restructuring, but no, it can't possibly change. So there are dangers. I think the one example that is an interesting one in response to your question is Manuel Cepeda from Colombia. So Cepeda was very involved in 1991 in drafting the new Colombian constitution and was not appointed to the court until 2000. But he was appointed at a moment where the court was drifting in the sense of, you know, had become more and more ambitious, and the political elite support for the court was getting incredibly diminished. And they were actively debating, radically amending the jurisdiction of the court to cut it right back. And Cepeda comes on 9 years later, his incredibly political, you know, skill, and he just rights the ship. He's like, we're just going to pull back, we're not going to reverse our course, but we're just going to pull it in a little, right? And he pulls in their social rights jurisprudence to the point that it can be managed, and the court retains its jurisdiction. And so I think the kinds of judges that I'm studying are the judges you need to establish a court and to make it successful, and then to kind of help it weather the storms that come up when the political branches are really out to get the court. And that will tend, you know, as I said to Judy, there will tend to be in some sense, in some early-ish period, right? But early-ish can often be the second generation, so it can be 10, 20, 30 years later the crisis really comes, because think about South Africa, right? While Mandela was president, the Constitutional Court would survive. He was so deeply committed to the rule of law and a vision of constitutionalism that it didn't matter how bad those guys were, he was going to stand up for them. You get Mbeki and it's like, you know, game on. It was really up for grabs again, whether there would be constitutionalism and the rule of law. And so I feel like actually, you know, and this perhaps goes to your point, Mark, about is it actual continuity or kind of relative continuity? Because sort of early, you know, transition to the next generation can be another moment of vulnerability where these kinds of judges may be important.
I just want to say a couple of things. One about the transition point. I do think it's understudied. And in this context, we actually have, I think, two pretty good cases that need to be paid attention to. The first is Hungary, where I'll oversimplify it, but the first, they made this unbelievable design error, and all of the justices, the terms of all the justices of the first Constitutional Court ended simultaneously. So you just had a complete replacement of the court. Now, and things were different, but we don't have a good study of how they were different. And that all of that is before the most recent stuff. So, okay. And there is the South African Constitutional Court, which is just a different institution from the one it was when we all started studying it. The other point I want to make is one of the things that I think we have to think about is that at some level we're dealing with when we're dealing with the successful ones, drafter judges and the like, the ends are really small. Yeah. And so, you know, maybe the Colombian story is about the particular character of Manuel Cepeda, who was, in this interim period, among other things, a world-level diplomat. Okay, and Barack was sort of everybody acknowledged, literally everybody. People who disagreed with him violently agreed that he was the best lawyer, smartest lawyer in Israel. So when you're dealing with with that, maybe there are no generalizations available.
Any comment, anything?
No, I mean, no, I agree with what with some of the things that Mark mentioned, but maybe I was just wondering, maybe this has to do with those who are not Herculean judges that are the subject of this paper. But what about judges in places? I was thinking here particularly of the post-Arab Spring countries where everything is being built from the ground up, and one of the constitutional or the Supreme Courts in those places are going to be one of the major institutions that people are going to look at to see if the society is going to have any chance. I'm here thinking of Tunisia in particular. And so, I mean, and all the judges in the Tunisian Constitutional Court are all professional judges. And I'm just wondering if, like what insights can we get from that study, and then what can we apply to these kinds of places?
I mean, if I'm right and it matters, then the answer is you'd want them to kind of bone up on their politics, right? Seriously, it matters, and that Herschel, who you reference, has done some studies about how some courts have been very skilled at mediating the tension between politics and Islam, right? The Pakistani court has this amazing doctrine which is extremely, deft at navigating that tension, and I think they should go on a study tour if they have no political experience, and go and figure out how the Malaysian and Pakistani judges have done it well and done it badly, because it will matter, right? If those people are not politically astute, the court will fail, is the answer, right?
The people nodding, people shaking their heads. But it's 1:30 and we have to stop here because there will be a cab waiting for Mark. We can move in informal session if people wanna stay around. Anyway, please join me in thanking the panel for.